Okay, have we got everybody in now?
Yes, I think so.
Righty-ho. Well, great. Well, welcome everybody. Welcome to the APPG for Miscarriages of Justice. My name's Bob Neal. I'm the co-chair of the group with my colleague and friend, Barry Shearman. Great to have so many people with us. We're going to be talking today particularly about compensation for miscarriages of justice. Obviously, what's happened with the post office case has made that particularly salient and topical, but it is something that goes beyond that, of course, into other types of miscarriage of justice cases as well. So there's a broader application too, but naturally the post office case is something that's going to feature very strongly with what we're talking about today, both what happens there and perhaps also the broader lessons that we can seek to draw from that. We've got 4 speakers, and so we'll run through each of those and then try and fit some questions in towards the end. So without more ado, let me introduce the speakers. Laura Tilt, who's a pupil barrister at Pump Court and also the co-author of Not Innocent Enough, a publication dealing with state compensation for miscarriages of justice in England and Wales in 2019. And I know, Laura, you interviewed hundreds of people who'd experienced miscarriages of justice in your research. Jo Hamilton. Jo was one of the one of the sub-postmistresses who was wrongfully convicted, and that was overturned, glad to say, Jo, by the Court of Appeal. Neil Hudgell, Dr. Neil Hudgell, good to see you again, Neil. Neil is the executive chairman of Hudgell Solicitors, who, as you know, acted for quite a number of the post office appellants successfully, Jo included, and has very wide expertise in this area. And Jodie Blackstock, who is legal director of the Policy Reform Charity and Law Practice Justice. Justice is, as you know, a group which intervened to support Victor Nealon and Sam Hallam's case before the Supreme Court, which is now going to the European Court of Human Rights. And of course, Justice has done a great deal of other work in this field too. So, shall we kick off, Laura, perhaps with what you found during your research and your observations? Over to you.
Yes, sure. Thank you very much. It's really nice to be here to speak to you all. I should probably clarify that I haven't spoken to hundreds of victims of miscarriages of justice, because the pool, in fact, in England and Wales, certainly of those that are able to be contacted, is actually much smaller than that. What I have done is interviewed up to approximately 60 victims of wrongful conviction in England and Wales, and also those that have supported victims of wrongful conviction in England and Wales in what I call the aftermath. And that's very much the focus of my research, is what happens after a quashed conviction, and what are the impacts of wrongful conviction, particularly in this current climate where, of course, compensation is almost impossible to obtain. I have also, in addition to the qualitative interviews that I've conducted, I've also done a more quantitative study of all clients of what's called the Miscarriages of Justice Support Service. And that service is the only state-sanctioned service in England and Wales that provides support to people who have been wrongfully convicted, usually after being referred from the CCRC. And they support these individuals and their families in trying to pick up the pieces of their lives. My research from that study, so basically I looked at all of the client files that service retained to get a bit of a picture of how wrongful convictions impact on people and on their families. And I just thought it'd be worth giving some of those headlines of what I did find to then give that sort of bigger picture. The first is in relation to housing. So of all the clients of the MJSS, I found that over half, or just over half, were either homeless or living with friends and relatives 6 months after release or after their quashed conviction. And that's quite stark, given, of course, that wrongful convictions happen through no fault of the person. A quarter of those at that point, at 6 months after, end up in social housing provided by council, and then this sort of increases as the years go on. And what I found, particularly in relation to those clients, is that it ends up being sort of half and half, whereas 50% are living with friends and family, couch surfing and that sort of thing, and 50% are relying on housing, sort of local housing from the council. The difficulty with that for people who are wrongfully convicted is that they don't fall, or they don't have fit into a particular box after their conviction is quashed. And they are the boxes that we as a society sort of provide. One of those, for example, is when you're applying for housing and having to apply for what's called priority need housing. Now, being an ex-prisoner, or an ex-offender more specifically, is one of those categories. But of course, if you're wrongfully convicted, that doesn't necessarily apply to you. And having to try and explain yourself to these, to housing associations and these sort of bodies that don't necessarily have experience of wrongful convictions can be very difficult. And so housing is something that that often came up in my interviews and also in my quantitative research. The second impact was financial impacts of wrongful conviction. And of course, it's no secret that legal proceedings can be extremely financially onerous. And so even though a lot of people that I, or the clients that I reviewed had been employed, just over 3/4 of them had been employed prior to being wrongfully convicted. By the time their conviction was quashed, 94% of them were having to rely on benefits to get by. And just a third were employed in some capacity after their release. And there are lots of issues associated with that. Employment, of course, you not only lose the employment that you had by way of being wrongfully convicted, but often people had a lot of time out, whether you spent that time in prison or whether that was just time waiting for your appeals and then further appeals. That time means loss of skills, it means loss of being in touch with society, and of course the psychological impacts of wrongful conviction have these knock-on effects to those additional aspects like employment and also on people's finances. And so those are the sort of main, I guess, headlined impacts that I found in my research in terms of how, what wrongful convictions do to people and to their lives. And what I'm currently doing now is turning a lot of this research from those people that I've spoken to and of this these studies of the client files. I'm turning it into a book, which is based on all this research that I've done for my PhD. And one of the main, I guess, themes in that book is the way in which wrongful convictions impact on people's identities. And it's this having to regain either a new identity or trying to pick up the pieces of the identity that's been shattered by a wrongful conviction. And so with those impacts in mind, it gives you an idea of how compensation could assist with rebuilding that identity and with people, or at least assisting people to pick up those pieces and put their lives back together. And when I spoke to or interviewed people who'd been wrongfully convicted, I did speak to people who had received compensation, so they received it prior to the law changing. And then I also interviewed people who hadn't received compensation because they'd been wrongfully convicted, or at least had their conviction quashed after the law had changed. And there were some real differences there. I mean, of course, there were very individual stories, but a lot of those individuals that had received compensation were not the ones that were homeless. They weren't the ones that were in or having to try and obtain local housing. They were at least able to provide a roof over their heads. They were at least able to get by, even if it meant having to also rely on benefits. It was just building this social capital that had been lost by the wrongful conviction. And finally, compensation can not only help with these practical impacts of wrongful conviction, but it can also help with this idea of deservingness. And I think that's something that is really lost in this change of law and the way in which compensation is now so difficult to obtain. Because some of the stories that I was that were relayed to me, one in particular, for example, were stories of individuals, other members of the public, even police officers, asking people who had been wrongfully convicted whether they had obtained compensation, because that somehow made them more legitimate than those who hadn't. That, I think, is a very sad story, because especially when you consider people who are in the most extreme end of wrongful convictions, so they've been through the CCRC, they've had the appellate system fail them as well, the fact that they are seen as not deserving enough for compensation is, in my mind, something that is very, very sad and something that we need to raise awareness of.
Great.
Thank you.
Well, thank you very much, Laura. That's very helpful introduction for us. Appreciate it. Can we then move straight over to Neil Hudgell? Neil, I know you're going to talk about the background to the post office case and beyond. Over to you, Neil.
Thank you, Bob. Thanks for the kind introduction. And I passed the first test there by coming off mute.
It is the first initiative test, isn't it?
It is indeed, yes. I'm delighted to be here as part of a double act with one of my clients, Joe Hamilton. Sadly, it's not a comedy double act. Or if it was, it'd be some sort of tragedy. Where to start with post office? It's difficult in a sense because there's been so much said and so much written. But I think with the Court of Appeal outcome, it's sort of been the first time where the mainstream media have grabbed hold of what's gone on and actually got to grips and understood the breadth of the case and the issues involved, and just the sort of systemic sort of institutional behaviour that has brought about what I would describe, and I think most people would describe as the biggest miscarriage of justice, both in terms of numbers and in terms of duration. So we had 39 quashings in the Court of Appeal in April. We've had some in Suffolk Crown Court, so I think we're at 47 at the moment. And Post Office wrote out to about 600 other convicted people in recent weeks. And so if you compare that with very sort of high-profile cases such as Guildford 4, Birmingham 6, etc., you can see the enormity of the actual litigation. And as I said, I could talk for hours about the litigation, but I suppose that if we're focusing on the effects that the process has delivered to the people and the victims in question, I think my observations are fairly straightforward in a sense. We're dealing here with an organisation in Post Office in 2000 that rolled out an IT system that cost tens of millions of pounds, with glitches, with flaws, with potential to throw up errors and bugs. And instead of accepting that and rowing back and holding hands up and saying, actually, we may have overspent on a dud here because of reasons of, I don't know, for vanity, for having to account to somebody up the food chain. They rolled it out, and in the process, we went from a nation of honest shopkeepers that were being prosecuted at the rate of 2 or 3 a year to a nation of dishonest postmasters at 60, 70, 80 a year. And that behaviour carried on for 15 or so years. And I think the sad thing is that the tactics that were employed by an organisation that was both judge and jury, prosecutor, victim, and also beneficiary, which fortunately now we have safeguards to prevent that, meant that whilst every postmaster had one piece of the jigsaw, post office had them all, so they could see what the picture was. You had honest people like Joe that were serving their communities that were hauled in. They weren't making vast fortunes, they were just making ends meet, but they were hauled in, sacked on the spot, in many instances walked out the front door and the sign goes up, and labelled as dishonest overnight, until that there was a robust system in place, and it was their doing, and that's not where the nightmare ended, of course, because they went to court and the post office had deliberate tactics around taking lesser offences if a reason was held to be robust, and the defendants said that as part of their in effect plea bargaining. So it was only through the likes of Joe and people like Alan Bates that campaigned hard and continuous that allowed this miscarriage to see the light of day. And obviously now we have the first tranche of those convictions overturned. There's a lot that sit behind it. We look after about another 100 clients of the 600 or so. And there's a long way to run with this, and I think probably it would be a good time for you to hear. I've got some observations about some of the effects that it's had on people, but I think there's no better advocate than Joe herself to talk through the story.
Yeah, I think that's good sense, Neil. Many thanks for that introduction, though. Joe, shall we bring you in now and sort of tell us about what your experience was, and I think you and Neil are going to have a bit of a conversation about some of that as well as we go on. So, Joe, great to see you here, and
thank you.
So sorry, to learn of everything that you've been through. It's deeply shocking, but thank you for coming to help us to try and help these things not happen again.
So I begin at the beginning. I took the shop over in 2001, and the computer system went kind of electronic in 2003, and I hadn't had a minute's bother with it until it went electronic and chip and pin came in, and then my problems began, and I got deficit after deficit. I got to the end of the week to do the balance, and when I had problems like a minus £2,000 error, I rang up the help desk and they turned it into minus 4,000 with the things they told me to do. Anyway, cutting a long story short, every time you challenged anything and said, well, I didn't owe 2, let alone 4, they just said, well, you've got to pay it. And then when you don't have the money to pay it, they keep your wages. So they were keeping 2 lots of wages, and then more deficits came, and I put that in. I borrowed money, put it in, and then I couldn't keep up with it. I remortgaged, put £9,000 of my house money in, and it just kept going wrong. And I knew every time I phoned up for help, the party line was, well, if there's a deficit, you've clearly made a mistake or someone's taken it, so you've got to put the money back in. And so I let the amount climb to £36,000, and then I rang up and said, could someone please come and help me, because a friend found me in a bit of a state on the shop floor one night. I rang up for help, and the next morning I rang up the Federation of Sub-Postmasters, and they said, well, you better go find yourself a good criminal lawyer and we'll arrange an audit. So the auditors came in the following morning it was a couple of days. They came in and came round to my house. Fortunately, I was one of the fortunate ones that I jointly owned a property with my parents. Otherwise, they would have taken the house like they did with so many people. And my mum stepped in and said, "This is my house too." And he sort of backed off and said, "Well, what have you done with the money?" I said, "Well, I don't know. I have no idea. I can't get to grips with the computer system." And then a lady in the village was a lawyer. So I went to her and told her what had happened. And she said, "Well, you've got to make them do the next move." So they then proceeded to charge me with a theft of 36,000. So I went then through the criminal justice system, which if you've never been in it is quite horrendous. And almost 2 years later, I ended up pleading guilty. They did a last minute plea bargain because I'd always pleaded not guilty to theft because I hadn't stolen anything. And they did a last minute plea bargain and said, "Well, plead guilty to false accounting and we'll drop the theft." So the legal advice was to plead guilty because they were going to get me for false accounting. And then there was a chance I might not go to prison. So I pleaded guilty to false accounting. They dropped the theft, but they kept the threat of the theft charge on my file in case I didn't pay the £36,000, because that was the other thing, that I had to repay all the money and I had to pay £1,000 cost. So they took £37,000 off me. And being very lucky, I guess the people in the village realised I don't think any of them could quite believe it. They all turned up in Crown Court to support me. And the judge clearly knew something wasn't right. So he actually then said he wasn't considering a custodial sentence, because up until then, I've been told by my probation officer on my pre-sentence report that I was 75% likely to go to prison. So I packed my bag and prepared for the worst. And he then looked at 74 people in court and just said, I'm not considering a custodial sentence. And so I actually went home, which was quite incredible. So then I had the long business of, I had a 12-month supervision order. So I used to have to go to the probation office every week and sign in. And it was a bit of a joke, really, because nobody actually thought I was there for anything other than drink driving. So, yeah, I had the embarrassment of that. And because of all this debt I was in, because I lost my post office salary, my mortgage became much bigger and the interest rates were much higher back in the day. And I just literally scrabbled around everywhere for money to keep the whole place going. And I ended up losing the shop, and I couldn't get employment because of my criminal record. So I ended up working as a cleaner for everyone who knew that I was honest and I wouldn't steal from anybody. So I worked for about 8 different people cleaning their houses, got the keys to all the houses, and that's the best work I can get, because I know whatever job I went to get, I've got it, or up until the 23rd of April, I had a criminal record for fraud. So it stays with you. I went to help out volunteer at my granddaughter's school, and I got asked to leave because the classroom assistant had to leave and they couldn't leave me on my own in the room with the children because I had a criminal record, and they obviously knew me. It was embarrassing all around. They didn't want to do it, but they had to. And basically, my parents who bailed me out have both since passed away. They both had strokes, and I blame the stress of it all on this. And so I'm fortunate to still be in the same house, but I have to work blooming hard to keep the mortgage paid, and I'm on payment arrangements with various credit cards I got into. And the whole thing has just been a financial nightmare. But because mine hit the press because so many people turned up in court, we gradually realised the party line was, you're the only one that this has ever happened to. People rang me up and said, I know someone else this happened to. And gradually, from 2009 onwards, we formed a group, and it got bigger and bigger. And we realised that actually we were all telling the same story. And we've tried various things. We've had select committees. You name it, we've done it. But eventually we had the massive High Court trial in 2019, which, in spite of trying to sack Justice Fraser halfway through, they didn't derail it enough, and we had a fantastic victory, but at what a cost to everybody, because there was almost no compensation from that. I haven't even had a third of the money that I've actually lost, let alone any other damage of being 18 years of my life being ripped out. So, yeah. So we're here today. We got our convictions quashed on the 23rd, thank goodness, because, I live to tell the tale, but I must admit,
sure.
I know a lot of people haven't fared as well as I have.
Yeah. Understood. Okay, well, look, thank you very much, Joe. That's really helpful to us. And thanks for sharing that, such a traumatic story with us. Neil, was there anything else you wanted to bring out in sort of your thoughts with Joe, conversations with Joe at all? Or have we?
Yeah, I mean, I think, I'm in dangerous territory because I don't often get a word in when I'm having a conversation with Joe. No, we try. She's a very inspirational lady. And I think what I'd say to you, Joe, is that you've always been quite upbeat about the situation, and I think you view yourself as one of the lucky ones. I mean, it might be because you do have great networking with a lot of the other victims. It might be just useful if you could sort of articulate, probably on a no-names basis, one or two of the more sorrier stories, because your community stuck behind you. We know of other examples where that wasn't the case. Just give us a flavour of a couple of others that were less fortunate than you.
Yeah, people came to me because they knew no one would believe them, because of their ethnicity, basically. And we just had to help them, They turned to me, and people rang me almost suicidal. And Alan always used to give me the people that he was never very good with words, so he passed them over to me. And we just kind of scooped them up and helped them as best we could. Yeah,
I mean, one of the real tragedies that we see in so many stories of people that have gone before there's been exoneration. Obviously, we had Karen on the steps of the Court of Appeal talking about Julian Wilson, who died.
He was such a strong, the two of us, we went to the first select committee hearing, we went to all the meetings and everything together. And I went to see him just after a JFSA meeting, and it was 3 days before he died. And I promised him that we would never stop until this was sorted out. Just like my parents, I promised them I'd never stop. And 4 days after my mum died, it was the first case management conference. And I made her a promise that I would never stop until it was sorted out.
I was going to ask you that. How do you feel that your mum and dad were here to see that day on the 23rd of April? How does that make you feel?
No, it's horrible. It's horrible, really is. Because they literally financially fell behind me, and they racked up their own credit cards to keep the blooming shop going. And, it's awful. It's awful that they weren't here.
I suppose a sort of quite a topical question, given what we're discussing today, is you're a very pragmatic person. We are where we are, aren't we? Convictions quashed, you're innocent, you're exonerated. Going forward, what will make it better?
Well, money would help, because I have lost. I'm still having to work my fingers to the bone to try and keep all the balls in the air to pay all the bills, and I shouldn't be in this situation. I can't quite believe we're still actually in a journey. You think your conviction's going to be quashed, it's all going to be over, but it isn't.
Okay, I think that sort of covers off some of the main issues for us. I mean, I think in terms, Bob, in terms of the sort of core of post office clients, some of the things we haven't covered off, and some of the consequences are the psychological and physical damage, the stigma attaching to it, the trauma. Some have lost lives, some have tried to take life, some are on lifetime medication, some have never been fit enough to work again, and they all most commonly have a continuing financial need to a lesser or greater extent. And what we're embarking on now is a claim in damages for each of those people, which is fairly onerous and difficult quantification exercise in a lot of cases, because a lot of this goes back a long time and covers off a variety of heads of claim. So I think the key message from people like Joe, myself, and everybody else involved is that there needs to be some way of early interim compensation to in effect numb that pain quickly. Whereas at the minute we're in a little bit back into a bit of a hiatus where we're going through a process. And these are people traumatised by litigation. The last point I'll make is with all the new people, the convicted people that were written to by Post Office in the last few weeks, not so many have come forward. And the sort of anecdotal evidence I'm getting for that is that people are frightened of the process. People are traumatised. And I think you would back this up, wouldn't you, Joe, that people are traumatised and scarred by the whole process and are just frightened to reopen it.
Sure. We have a man locally to here who is terrified of the whole thing and won't. They destroyed him, and he won't come forward. And I've tried to encourage him, but he won't because he's terrified of the whole thing. And it's wrong. It's just wrong.
Yeah, absolutely. Yeah, fair point. Very fair point, Joe. Okay. Well, look, Joe, Neil, thank you very much for that. That's really powerful and very helpful, and some very useful specifics for us, particularly parliamentarians, to take away there, Neil. Thank you. Shall we then move to our last speaker, and then we'll have time for some questions, which is Jodie Blackstock from Liberty. Jodie, over to you.
Justice, Bob, but never mind. Jodie from Justice. Yes, thank you very much for having me here. No worries.
End of a long day.
Sure. Thank you so much, Joe, for sharing your story. And I know it must be hard to keep having to talk about it, but hopefully this is a forum which is supportive and from which we can offer you our terrible condolences for what should never have happened. I'm going to talk about the statutory scheme that's available for compensation today. I know there's a number of people on this call who have been through a similar situation to you, Joe, from the way the police have and who have been able to obtain compensation. People like the Birmingham 6, the Guildford 4, and others. But we're in a situation now where the compensation scheme does not work and people are not able to obtain compensation in a way that they are entitled to, having suffered the trauma that you've described and continuing to suffer that over many, many years, because it doesn't go away, sadly. The experience of being wrongly accused and serving time in prison when you should never, ever be there. There is a right to compensation in the International Covenant on Civil and Political Rights, and that exists where a new or newly discovered fact shows that a miscarriage of justice has taken place. That law was brought into force in our country in 1988 in exactly the same language as the international instrument provides. It doesn't define miscarriage of justice, and that's where the problem has occurred in our country. But the Oxford English Dictionary defines miscarriage of justice as a failure of the justice system to attain the ends of justice. And that probably should satisfy everybody of what needs to happen. It hasn't in our country. Before 1988, we had a discretionary scheme, and the Home Secretary, as it then was able to award compensation where it was shown that someone should not have been was wrongly convicted of a crime. And it was in recognition of the fact that they should never have been there. That scheme was abolished in 2006, and we no longer have any discretionary process to deal with terrible situations like the one that you've been through. Under the statutory scheme, it is necessary to show a new or newly discovered fact that wasn't available at trial. And there was a lot of litigation around what a miscarriage of justice in that context means. It led to judicial review, after judicial review, to the House of Lords and back again. And in a case in 2011 called Adams, the UK Supreme Court looked at the issue again, and it decided that there were two circumstances where a miscarriage of justice could be said to occur. One of those is factual innocence, and the other is where the new evidence is such that no reasonable jury would have convicted if they'd known it. And that seems pretty straightforward. But unfortunately, in 2014, the government decided that wasn't enough. It needed to be clearer, and they presented before Parliament a new test. And that new test requires that the new or newly discovered fact shows beyond reasonable doubt that the person did not commit the offence. So that's an innocence test, the burden of which falls to a criminal standard upon the person who has just been acquitted by the Court of Appeal. It doesn't even apply on a first appeal, what we call an in-time appeal. So conviction by jury in the court, you can apply to the Court of Appeal within 28 days for that conviction to be overturned, where it's considered to be wrong in law or something wrong happened during the trial. It doesn't even apply in that kind of case. There is no compensation in this country for that. This applies where someone has served a long time in custody or a long time has passed since, and they are able to show new evidence that wasn't available at trial or wasn't used at trial. So that's already a massive hurdle. To get that before the Court of Appeal Criminal Division, it has to go through, almost in every case, the Criminal Cases Review Commission, convincing them to look into whether a case was wrongfully convicted or not is a massive hurdle. When it goes to the Court of Appeal, it's a massive hurdle to convince the judges that that case should be overturned because they're testing whether it was unsafe or not. And that's a really high hurdle. So finally, if the Court of Appeal says this conviction is unsafe and quashes the conviction, there is a certain amount of euphoria at that point because the person can be released from prison or their name is cleared. But suddenly they find at that point they've now got to convince the Secretary of State on that new evidence that it shows they were innocent. But nobody's asked that question until now. They've been asking if the conviction was unsafe or not. It's the other way around. It is almost impossible to satisfy. Hopefully, on the post office cases, if you were to apply through this route, you would have that evidence because the problem was obviously in the system, in the accounting system that was used in the computers. But for a lot of people, it isn't possible. And the challenge which is now before the European Court of Human Rights is trying to address that problem. And it's taken all this time and we're still waiting for that case to be heard. I think the appellants have till the end of this week or thereabouts to put their cases in. And that's in the case of Sam Hallam and Victor Nealon, who have between them served almost 30 years of time in prison for the crimes that they did not commit. Both claims were rejected for compensation after the test had changed. One of them had alibi evidence and the other had DNA evidence, and it still was insufficient to show innocence on the facts of their cases. Victor Nealon's solicitor is on the call today and may be able to provide a bit more information on that when we get to the questions. the challenge that's been brought to the European Court of Human Rights, and the challenge that was made all the way through our domestic courts, was that this new test violates the presumption of innocence, which is provided by the European Convention on Human Rights, because it wasn't possible to challenge it directly since Parliament had approved it. So we're now challenging the very essence of the right to be presumed innocent following acquittal. There is a long line of cases in the Strasbourg court that looks at this issue, and indeed the leading case is already a case from the UK. And it's very clear to justice, and it's very clear to the appellants in their cases, that this test does offend the presumption of innocence, because what it's doing is it's suggesting that there is some doubt about the correctness of the acquittal, that there is a failure through the scheme to dispel suspicion about the acquittal and the innocence of that person. Because if the Secretary of State does not accept the finding of the court, then it has to logically follow, in the minds of everyday people, still was guilty to some extent. That's what everyone would think. And that's why the Strasbourg court has said, in this kind of circumstance, it is a violation of the presumption of innocence to require innocence to be proven. Now, the UK government doesn't accept that, and indeed the UK Supreme Court didn't accept that, which is why we've gone to Strasbourg. So it's not necessarily as clear-cut as I'm suggesting it is, because in all these cases, lawyers argue. The UK Supreme Court thinks that our test is nothing to do with the presumption of innocence because it's nothing to do with the criminal courts. It's a separate civil application. But we don't agree with that. Then the Strasbourg court has not agreed with that in all of the cases in the past where it has been asked that question. Now, what could you do differently is perhaps the question to be asked. How do you compensate people without causing all these problems? And this is the basis of the intervention we put into the court in Strasbourg to support Victor Nealon and Sam Hallam's cases. The vast majority of other countries that are a party to the Convention on Human Rights simply have a test that where someone's conviction is quashed, they're entitled .
Like Jodie's frozen a bit there, doesn't it? You okay there?
Sorry,
right, you might have frozen a bit. For that second.
Am I back in?
Yeah,
You're back now.
You're back now, yeah.
No, you're not.
No, we're not. No, we're coming and going a bit.
Can you hear me okay? Sorry.
You're okay at the moment, Jodie, yeah.
Yeah. There's a bit of a problem on the line, I think, from my end.
I think you were just sort of wrapping up, weren't you? Yeah.
I was, yeah. So just to complete the point.
Yeah, please, yeah.
In Scotland, we have the same compensation legislation.
I think we're starting to hit the same problems again now by the look of it. Yeah.
Sorry, it's in and out. Just whilst I'm not frozen, there are other ways of doing the process of compensation, is my point, and other countries have managed to do that.
Indeed, so yeah.
Our question would be, I suppose, to Parliament, given that's where we are today.
Yeah.
Do we have to wait for Strasbourg to decide that this test is in violation of our human rights, or can we get on and simply have a straightforward test that allows?
Yeah. Okay. I think we've sort of got the picture there, that Jodie was talking about there, haven't we? About tests and other ways in which we could do it, which does make a fair point, doesn't it? What I'm doing now, I'm scrolling through because we got some questions, and let's see what we can do. See what comments we get from our panel on that. One actually sort of builds on what Jodie was saying. This idea, in a sense that people are told that they weren't innocent enough, and I think maybe I'm right in saying that probably that case is an attempt to seek to rectify that situation, unless I'm wrong, Jodie. I think that's...
Yes, it's absolutely that. Sorry, I was muted.
Yeah, don't worry. Yeah. I mean, and Neil, from your point of view, have you picked up that sort of issue as well, and the cases that you've dealt with?
Don't get my finger on the unmute button. Yeah, very definitely. I mean, in relation to the post office cases, I suppose there's quite a discrete issue here because there'll certainly be, we've looked at the idea of state compensation, and it's taxpayers' money, and there is obviously a private company that's the prosecutor here, albeit one that's that only has one shareholder. So it would be even less likely, in my eyes, to respond, and probably ought to be viewed. And this is what I'm saying to the clients: viewed very much as a fund of potential last resort. Yeah.
No. Okay. Now I understand that. Yeah. Thanks. Thanks, both. Another point is raised about this rather bizarre situation where the government argues and seems to have succeeded, or sort of seeks to deduct monies to, in effect, cover board and lodging when people have been in prison, which you might think is adding insult to injury almost, isn't it? What's the position as far as that's concerned? Is that something that's being challenged at the moment?
I'm not sure that it is actually, Bob. I think the primary concern is even being eligible.
Sure.
A whole slew of other problems with the cap on the amount that you can claim for. That's been brought in over the sort of last decade. And as you say, board and lodgings, it's pretty horrendous that you get that removed as well. But yes, I mean, I think one step at a time, if we can get actual eligibility back to something realistic, then maybe we could look at that next.
Maybe we could look at that next. That's a fair point. Okay, yeah. And that's something perhaps for parliamentarians to start having a look at as well, because I don't know whether that's done by regulations or some other reason, but it's worth us looking at. An interesting point here, and I think Jo hit upon this, when she felt that some people, because of their ethnicity and background, might not be believed and didn't get the level of support that she had. And the question here is, has part of this happened because of what our questioner puts as the inherent culture of poor representation of ethnic minorities in the judicial system arguably contributed to this? And what can be done? My select committee, I might mention, has got a hearing with the chairman of the Judicial Appointments Committee next month around equality and diversity in the judiciary. But what can be done in other respects in that regard? Any observations on those, perhaps? From any of our panel, I mean, Jodie, others as well.
Well, Bob, as you know, the issue of racial disparity is something which Justice has raised concerns about for a number of years, not only on the issue of judicial diversity. We continue to ways to ensure the pool is more diverse for our judiciary. The experience of judges sitting on the bench of colour is also one that is not necessarily satisfactory, and that's something we're looking at the moment, stories about the way that they've been treated. But from the other side of things, there's a problem of racial disparity in the people who are stopped by our police and in the people who are charged, convicted and sentenced to prison. There is something that still needs to be done about this. We wrote a report this year on
Okay, I think we're having the same Same bit of freezing again, but not to worry. Yeah.
Sorry, I have to apologise. I'm not at home, and I'm using someone else.
It happens to. I'll tell you what you could do. If you've got any other bits, you could add any further comment into the chat, which might be a good way of getting the message across.
I will try my best.
Just in case. Yeah, I know it's not easy, but thanks. We got a lot of it. To be fair, so it's just trying to get that in. And then is Lord Taylor still with us? John, are you still on the call?
Yes, I am. Can you hear me?
Yeah, I can, John. Yeah, because I know you had a question that you put in.
Yeah, I'm actually very interested in the ethnic minority aspect, and I don't know if it is known how many of those who are convicted are from the ethnic minorities. That would be nice to know. But also, in the chat, it's quite clear that there are other criminal jurisdictions that deal with this whole area of the time taken for appeal and also compensation if successful. They deal with it much better. And I'd like to know which nations deal with this whole subject in a more, in a fairer way, because we need to look more into the nuts and bolts of those particular process.
That's a very helpful point. Any of our panel, any of the four, you got any thoughts on that one? That's really interesting.
Just on the point about ethnic minorities, I think it's interesting because of my research. In fact, of the people that sort of finally get through the CCRC and end up having a quashed conviction, a lot of those individuals are not from ethnic minorities. They are mostly white, British, or the like, which I think is a very interesting point, because that is, as Jodie was saying, there are, of course, issues with racial disparity in the criminal justice system, but I think there are also issues in terms of the appellate system, and that might be down to the amount of legal advice that they seek in order to start off with appealing in the process, and then that very lengthy process through the CCRC. So that is certainly something that is of an issue, because it of course doesn't reflect the racial disparity of convictions in and of themselves. So yes, I would agree with that.
Yeah, okay, that's very helpful to have. Thanks. Any other observations on that one? I don't know if anyone else has picked that up.
Just on John's Lord Taylor's point about the countries, I will put a link into the chat to our submission to the European Court of Human Rights, which flags some of that information for you.
That will be really helpful. Thanks. That will be really useful. Thank you, Jodie. That would be brilliant. Let's see what other questions we have got here that we might be able to pick up. Does a person who has spent time in prison before having the quick conviction quashed then become ineligible to serve on a jury? Yeah, that's an interesting one. It's also a little bit like, I know we have talked before about the position. Joe had that position of where helping out in a school, what was on her record. I assume, Joe, that is going to be expunged, and have you had assurances that that's going to be done?
I've had a certificate. I haven't actually checked myself, but I've got a certificate to show that it's been quashed.
Yeah, that's what you get, isn't it? Yeah. So I haven't actually checked it out, but it only came about because they knew that I obviously had a criminal record because it's a small village. But But there is this interesting. I don't know about juries. I would have thought the principle ought to be the same, frankly. But it might be worth our secretariat just checking up on that, because you think the logic says if the conviction was null and void, then the disability that goes with the conviction ought to be removed as well.
It makes it very difficult. Oh, sorry, Jodie, you go.
Go ahead, Laura.
I think it's the way in which questions are asked in these different circumstances makes it very difficult for people in these situations, because sometimes the question or criteria will be, have you ever been convicted? And so, of course, the answer for everyone would be yes. it doesn't allow you to expand or clarify upon that. So that is certainly another way. And someone did just mention in the chat regarding DBS checks. And this is something that I tried really hard to get a clear picture on, which I yet have to get, because it seems as though, in theory, your conviction will be removed from any DBS check. But actually, in reality, there are lots of discretionary boxes and things that the person filling out the form that then sort of gets filtered into the DBS check has. And so it may be in some circumstances that people's wrongful convictions appear in those discretionary boxes, which makes it hideously unclear and very difficult for victims of wrongful conviction.
Yeah,
that's our experience as well, and we're trying to work through that. I think your logic is right, Bob. In the sense, it's conviction quashes are void ab initio, but the reality seems to be considerably vaguer than that. In the same way we're trying to get bankruptcies annulled for some of the clients, as though that's never happened again. But of course, when they apply for credit, have you been refused credit? Same principle, really. It's still leaving a footprint that it shouldn't. Can I just very briefly come back to the first comment that was made earlier?
Please.
Well, only very briefly regarding the state scheme and the ceiling. The ceiling on compensation. Hearing what Jodie says, the battleground at the minute is in terms of eligibility, entitlement. But, if we get over those hurdles, we do have to have one eye on the extent of entitlement. Obviously, post office is different, but if you've got somebody that's held down a decent job 20 years ago and has never worked again since because of being dishonest, because of being unwell, you've got potential claims there that sit in seven figures. And so people are potentially going to miss out unless that issue is also addressed alongside, unraveling some of the sort of draconian eligibility criteria.
Thank you very much, Neil. That's very helpful again. And there's also a bit of a reference there that Jodie says that if you go on the Justice website, there's a number of reports there around some of these areas. There's a question, actually, we're all English lawyers here, but is the system different in Scotland? Asked one of our participants. The compensation system different in Scotland as opposed to England and Wales? I don't honestly know. I don't know if any of the rest of us have come across that.
Yes, this is what I was trying to say when my signal kept failing. The test in Scotland is the same as in England and Wales before it was amended in 2014. And it is applied. The guidance in Scotland suggests it is applied.
Yeah, that's great. Yeah. Okay, Jodie. Yeah. Okay, Jodie. You're back with us again now.
Yeah. You still need to have new facts, but you don't need to show innocence after.
Right.
It's a much fairer system.
Right. Okay. That's interesting there. And there's an interesting question here about what are the views on the levels of compensation to be paid to children, for example, where perhaps they might have been convicted, say, there's an example given here about the age of 13 and ended up for 3 years in a secure children's home, and then the conviction is quashed. Should there be any differentiation if they've gone to the CCRC about a conviction when they were a child? I mean, is there any differentiation? And perhaps should there be? One assumes perhaps the argument would be some aggravating factor in the level of compensation. Can anybody help us on that one?
I don't know that there is any sort of uplift. I mean, you'd have to argue sort of for the loss of your childhood, the maturing years, the importance, those social cues that you get, loss of education. I think you would want to put all of those things into the application. it's not automatic there, and a bit like we were saying about, you know, the records check for the jury, all of these things should automatically be done to support the person making the application. You shouldn't have to apply for your own records, guilty record, to be changed. And until that point, you're you know, going to not get a job anywhere. Exactly the same point with a children's case. It should be obvious that the detrimental impact is appalling on their to you know, mature, etc.
Okay, thanks. Unless somebody else wants to come in on that one. We're coming a bit towards the end in terms of the time that we've got, but there are more things if people want to add into the chat or indeed contact our speakers, then indeed the APPG Secretariat that we can do to try and follow through there. There's a question raised about will there be a forum on how to obtain withheld documents from police files? Well, let's take that one away and to ask the question from the AP point of view. Closure is one of the key issues here in wrongful claims generally. I think there's certainly some disclosure issues, as I recall, Neil, in the post office case, weren't there?
Many disclosure issues, yes.
Yeah.
And many surprises over when you thought there were no more surprises to come, they kept coming. So disclosures are a conversation in itself, Bob.
It is. It's something that it's always lived in my mind because when I was in practice at the bar, I actually prosecuted a guy for serious sexual offences, and it seemed on the face of it a very strong case, basis of what was being described by the young complainant. You imagine a child of that age couldn't have known unless it had happened to them. He went to the Court of Appeal first time round and lost, and then went back to the Court of Appeal for a second try, having changed his legal team, and lost. And then by the time he'd served his sentence, went with fresh information to the CCRC, and lo and behold, there were social services files that suggested that that unfortunate little kid had made very similar, strikingly similar, same factual allegations about a previous cohabitee of his mother's, and whatever the rights and wrongs, those files have been held back from the police. I think I was concerned about the relationship between somebody in the social services and one of the officers. But the CPS and I immediately thought, if we'd known that, we would have disclosed that, of course. And at this length of time, we couldn't say the conviction was safe. But that guy had done 7 years. And finally, because he felt so strongly, he went and got himself a DNA test. And it wasn't his DNA that was, in this case, circumstantial, wasn't totally probative. But that's always struck in my mind about the importance of disclosure failure. Because up until then, I and the CPS thought it was a strong case. So, it's getting that right is so critical.
Well, you had in the front of your mind your professional obligations, didn't you?
Yeah, you did, and that's what you've got to do.
The problem the problem with post office was they put their commercial interests, and this was part of the Court of Appeal judgment was. They put their commercial interests before complying with the law.
Yeah, and I think that's the real worry around disclosure. It's also a concern that we had a bit about in our Justice Committee report, which if people want to read on private prosecutions might be useful or helpful, because we were concerned about the objectivity of the private prosecutor, particularly when there's massive commercial pressures and so on, because that sometimes feed into that reminder that as you say, Neil, as a prosecutor, you've got an obligation, professional obligation, an obligation to the interest of justice first, and that got lost in some of those cases, didn't it? Very clearly.
Well, very very stark commentary in various places. Internal emails. Let's stop digging because we're not sure we want to find what we find.
That's just, that's terrifying, isn't it? That's terrifying in itself.
Absolutely.
But I hope that's given us a fair way through. There's a question about any way exonerees can get involved or help with the APPG. Well, by all means, I think if you contact say our secretariat here and the folk involved, then certainly Adam and others, we'd be very interested in when we're getting together evidence and panels for our future sessions. So by all means, feel free to follow that up. Well, look, I think we were getting to a stage where we probably need to wrap that up now, but can I just again thank all of you very much for coming and speaking to us today. Obviously, Laura and Neil, very grateful, Neil, and Jodie, but Joe, especially to you, because to relive that, something like that, isn't easy, but you've done it for the help and for the sake of others, and I think that's a real service. Many thanks to you, but also to everybody who's been on the panel and everybody who's participated, who sent questions in. We've tried to get as many as we can that were in the scope of session. We could have made a lot wider, but maybe that's something for another time. But I hope you'll continue to support the APPG and above all, the cause that people are trying to put right here. So many thanks. Take care of yourselves and speak soon. Take care. Bye-bye.